I am Palak Agarwal of Hidayatullah National Law University and currently a legal intern at LEXIS and Company. Today, I'll be discussing about defamation. Everyone has the right to have their reputation preserved. It is a right in rem and is acknowledged as a general rule. A right to reputation is same as the right to possession of one property. An unlawful interference with someone's reputation is a breach of duty, and the person liable for such interference is liable to pay damages to the person whose reputation has been injured. One difference between man and animal is that man is social in nature. It is indeed some kind of anomaly in the animal kingdom that even after being so different and not being related by blood, we live in close relations with each other in a society. And society has some rules and regulations. Some of these rules take shape of law and are backed by sanctions. Social boycott is the worst form of punishment ever given to a human being. A person's reputation is more valuable to him than the extent of his wealth, and his reputation should be protected at any cost, and the person who has injured his reputation must pay damages to the person. In India, every citizen has a fundamental right of freedom of speech and expression under the Article 19A of the Constitution of India. However, this freedom is restricted to the extent that it doesn't cause defamation. The two categories of defamation are libel and slander. Slander is a defamatory statement either in gestures or words, whereas libel is a defamatory statement either written or is in a printed form. Defamation is the publication of a statement without any justification that harms the reputation of the person or a business or a product or a religion. It harms the reputation of the person who is a plaintiff and lowers his reputation in front of other members of the society. The defamatory statement may either be in words or gestures or maybe in a printed form or in any other form. But it has to lower the reputation of the plaintiff in front of the members of the society. An important notion of defamation is that the defamatory statement should be published. Publication is when a third person comes to know about the statement made by the defendant. For example, A calls B a thief in front of C during an argument. B could initiate proceedings of defamation against A, provided that there was no truth in A's statement. And if C wasn't there when the statement was made, the defamatory statement wouldn't called as defamation, as the statement wasn't published. The defenses available to an action against defamation are truth. If the defamatory statement is truth, then according to law of torts, it is a complete offense. There can be no defamation if the statement is a fair comment for public interest. The third defense is privilege. In some cases, law permits a statement which is defamatory in normal circumstances.